the only show with no topic of limits, where all viewpoints are welcome and you live chat during the show. With your hosts from the West Coast, attorney and minister Vicky C. Jackson, from the law office of Vicky C. Jackson in Tacoma, Washington. With your host from the Central Region, attorney and minister Urena Ricks Johnston from Ricks & Associates in West Bloomfield, Michigan. And with your host from the East Coast, attorney, minister, and registered nurse Rossi Williams from Rossi Williams Law Group in Miami, Florida. So save the date and don't miss it. Watch and follow The Attorney's TV show, streaming every Thursday at 7:30 p.m. Eastern Standard Time on YouTube and Facebook. And get a text reminder when the show goes live by texting the word The Attorney's TV show to phone number 33222. And now let's join the attorneys.
Hello and welcome to the Attorney's TV show. I'm attorney Urena Ricks Johnson and I'm your host today. We have an exciting show for you today. I have my illustrious co-host, attorney Rossi Williams. How are you today?
I am well, attorney Urena. Welcome everyone. Welcome to our guest. We have a very informative show for you tonight. You do not want to miss this.
We also have another co-host, attorney Vicky Curry Jackson, who has recently lost her husband, and we have been in prayer for her, and we look forward to her returning to the Attorney's TV show. We also have a guest today, attorney Frank Allen from the Allen firm in Orlando, Florida. Attorney Frank, how are you?
I'm doing good. It's good to be here with you.
Yes, we welcome you and we thank you for coming on the show today. Today we have a great topics today concerning vaccine passports, vaccine requirements. But first, we're going to talk about the thing that has been in the news recently, which has been an incident at a restaurant in New York, where it seems that a waitress and a hostess was attacked by patrons from Texas while dining in a restaurant due to a vaccine passport requirement to be shown. And we're going to show some footage of this and go over this after we look at the footage. Let's look at that footage.
This is exclusive cell phone video of Thursday's attack outside Carmine's restaurant on the Upper West Side. Watch as the hostess stand is nearly tipped over. Tempers flare. At one point, a waiter helps carry someone away from the scene.
Oh, wow. That was bad.
We showed the wild brawl to customers. They are in utter disbelief, especially since the restaurant says it all started when the 22-year-old hostess simply asked a group from Texas to show proof of a COVID vaccination to dine inside.
We looked at this footage and it was very graphic when it showed these patrons attacking the hostess. But in this situation, the citizens from Texas are alleging discrimination. Attorney Rossi Williams, can you tell us a little bit about discrimination cases?
Yes, definitely. One of the main things that everyone should know is that if you're the plaintiff, the case is your burden to prove. I cannot state how many times people come in feeling that it is the defendant's responsibility to prove that they did not discriminate. It is your case to prove. And what we will see, of course, when you're dealing with EEOC cases is that the plaintiff brings the case or the petitioner, and they have to prove what we call a prima facie case. And then the burden shifts to the other person to just come in and show that what they were doing was non-discriminatory. But ultimately, once they've done that, which is very easy to do, the burden then again shifts back to the plaintiff. So many times people feel it's obvious that they were discriminated against. And it is not an easy case to bring, and it's not an easy case to prove. So when you come in, you want to have your ducks in a row, and you have to be willing to listen to what the attorney is telling you. Racial discrimination does happen, that is no doubt. But knowing it happened and proving it are two very different things.
Well, I've heard that discrimination cases are slam dunks. Attorney Frank Allen, what do you say about discrimination cases being slam dunk cases?
Well, I totally disagree with that assessment. In fact, I think discrimination cases are some of the most difficult cases that you can litigate. First of all, the alleged perpetrator or offender, they never admit to any wrongdoing. You can have videotape, you can have audios, you can even have documentary evidence. As you saw with the George Floyd case over the summer, notwithstanding the video, the officers were still claiming they didn't do anything wrong. So that's one of the first hurdles you have to get through. The defendant would never admit of doing anything wrong. The second problem that you have, or difficulty you have with civil rights cases, is that typically you don't have direct evidence, which means that you don't have someone using racial slurs or racial comments. If it's a sexual harassment case, you don't have, sexist comments, things of that nature. So you typically have to prove your case by circumstantial evidence, looking at the totality of the circumstances. And when you have to prove a case by circumstantial evidence, it typically leads to additional defenses that the defendant may have, specifically relative to the issue of intent. And I bring that up because in just about all of the federal statutes dealing with discrimination cases, you have to show that the person intended to discriminate against you. The next problem that you usually run across with civil rights cases is that you have to file with some type of government entity, be it the EEOC, the Florida Commission on Human Relations down here in Florida. However, in another state, it may be, for example, Georgia, the Georgia Commission on Human Relations. You may have to file with HUD. You may have to file with the Attorney General. And that usually takes time. And sometimes the client can get, impatient. They can get anxious. So that sometimes causes a problem. The next issue that you have with these civil rights cases, that they're almost designed to give the defendant or the employer or the offender a lot of defenses. Again, with the George Floyd case, we show this whole issue of qualified immunity. We see right now that that issue is right in Congress right now. They're trying to draft legislation to try to do something with this issue of qualified immunity. You have issues dealing with, pre-suit notice. I just mentioned the issue regarding filing with the EEOC or the Florida Commission on Human Relations. Well, if you don't file with those agencies, that's a prerequisite to file your lawsuit. And if you don't do it and do it properly, the judge will dismiss your case. Another defense that usually arises in employment discrimination cases is this defense called the Farragut-Adler defense, which is a Supreme Court case, which basically says that you have to go to HR or you have to make a complaint to the the employer, and put them on notice of what you're alleging to give them the opportunity to remedy whatever you're claiming was discriminatory. And finally, another issue is usually the clients, the expectation of the clients. Usually clients think their cases are, significantly more valuable than they sometimes are. So sometimes you have to temper their expectations and give them a more realistic perspective on the outcome of what they can potentially receive out of a civil rights case.
This is some great information. Only on the Attorneys TV show will you get this type of information. Now we're going to watch some more footage on civil rights claims.
Today, the ACLU, the NAACP, and Jacksonville's own Northside Coalition sued Governor DeSantis over the controversial so-called anti-riot law. That law gives police wide latitude to make mass arrests at protests, and it requires suspects to stay in jail without bond, even chills drivers who hit protesters. Coalition President
Attorney Allen, if you were representing the plaintiffs from Texas, what type of things would you bring in your civil rights lawsuit?
Okay, well, taking into consideration that the courts are giving a lot of deference to these restrictions regarding, vaccinated citizens, unvaccinated citizens, and COVID restrictions, they've been having rulings on these cases, and a lot of them have been in favor of the municipality or the state or the business or the employer. Now, based on the information I've gathered so far about this case, it appears that the type of case they will try to bring is what they call a desperate impact case. And what they're going to allege that requiring citizens or customers to have the vaccination passport before they can dine inside the restaurant is having a disparate impact on African American customers. And that's because African Americans are getting vaccinated at a lower rate than most citizens, white citizens, and other customers. Now, the problem they're going to have is that when you're trying to bring a disparate impact case, you have to show that that particular policy is having a disparate impact on a particular protected class. Now, the plaintiffs will say that the protected class is being African American. However, the restaurant will say, or the city of New York will say, no, judge, what they're trying to do is allege that being unvaccinated is a protected class, and it's not. Now, the next step they would try to do is try to, gather evidence to try to prove disparate impact. And how you do that, you have to show, typically by some type of statistical evidence, that African Americans are being, disparately impacted by this particular policy. You can show about, statistics. You can show by comparisons. You can show some anecdotal evidence by showing, here's a group of African Americans who tried to eat at this restaurant or tried to eat at restaurants in New York and they were denied, and it's because of this policy. So that would be probably the course they're going to try to take. I think it's going to be difficult, but that's the course that I can see them trying to take.
Okay. Attorney Rossi Williams, we know a major part of these lawsuits is damages. Can you give the audience a little bit about damages in a lawsuit?
Yes, damages are very important. Even if the plaintiff, which would be that person bringing the suit, meets all of the other elements, depending on what type of civil rights suit it is. Maybe you're the plaintiff who was a victim of police brutality, and so we're looking at Section 1983 claim, or maybe it's some kind of racial discrimination in your accommodations. Whatever it is, you must have some damages which we can quantify before a judge or jury, whomever you've chosen to be that trier of fact, so that you can be compensated. There are many times that people will bring cases and it is no doubt that some type of wrong or infringement on their civil rights actually occurred. But the problem is that you can't prove what the damages were. For example, let's say that someone was brutalized by the police 2 or 3 years ago, and it's taken that long to work their case through the system because the police criminally charged them with resisting arrest with violence or without violence, or something to that effect. And during those 2 to 3 years, the person has not gone to the doctor, not been to the hospital about this. The person is not seeking any counseling, and there were no severe injuries at the time of the incident, no fractures or things such as that. Then it becomes very hard to quantify before a jury what your monetary damages would be. Because most times in these suits, that's what people are seeking. In the footage which we saw in New York, that we were discussing in New York, I should say, that's what the plaintiff would be seeking, some type of monetary damages. And the other footage which we saw of Florida, that was not really a monetary damages case. That was a federal civil rights case where the people were seeking an injunction or a reversal of that law. But in most times, the plaintiff wants money. And when you come to a law office, the law office has to vet that case because they're taking the case, or we're taking your case on what's called legally a contingency fee basis, meaning that we don't get paid unless we recover for you. So the law firm is looking to see, will we be able to quantify the damages or explain through the evidence the damages enough to receive enough money to pay back the law office for whatever funds it advanced, as well as to try to recover enough to make our client or the plaintiff whole. So there must be damages, and they need to be more than nominal damages. This is why in closing, you will usually see that law firms will not take these cases unless you're seeing that the person has been severely injured, or tragically, if the person has passed away. because the law office is trying to see what would the damages be so that we can determine if we can proceed with this case to try to bring some type of financial justice to our client. So you could have everything, but if you don't have damages, it will be very hard to move forward in a case.
This is some great information, and a lot of times I know our viewers may hear of these terms, and we have our attorneys breaking these terms down and giving you valuable information. Live chat with us. Make sure that you follow us on the Attorneys TV show on Facebook, YouTube. We want to hear from you on these topics. Attorney Frank Allen, could you tell us what steps you take when you take on a civil rights case?
Okay, well, typically what we end up doing is that we will get the client to give a detailed and descriptive account of what occurred, of what they're alleging was discriminatory. And we try to do that as soon as possible. The reason is to, preserve memories, because as you know, when time passes, memories and recollections wane. We also make sure to instruct them to, preserve any type of video footage or audio information or any type of, emails or documentary evidence. So we can, have that available as we proceed with the case. The next thing we would do is that we would contact the company or the defendant or the offender and place them on notice. Let them know that, we're representing this particular client. We're going to be pursuing this particular claim. These are the facts and the allegations that we're going to be alleging. To give them the opportunity to, put their insurance carrier on notice, to contact us and see if they want to try to get the case resolved, pre-suit or before we file the lawsuit. And finally, what we would do is, contact the appropriate agency. You've heard me and Attorney Williams speak about the EEOC and HUD and those types of agencies. That's because, a lot of times just to file a charge of discrimination or a complaint with a particular government entity, that could be HUD, the EEOC. In Florida, we got the Florida Commission on Human Relations. In Georgia, maybe the Georgia Commission on Human Relations. Or in some instances, you may even have to file a complaint with the state attorney's office. So these are the steps that we usually take to get a civil rights case up and running.
This has been some great information. Thank you again, Attorney Frank Allen, for joining us. And if our guests want to get in contact with you, our audience wants to get in contact with you, how would they do so?
Well, they can call our office number at 407-481-8103, or they can email the office at fallen@Allen, firm, FIRM, like Paul Apple.com. Again, that's fallen, @theallenfirmpa.com.
And tell the audience again what your specialty of law is.
My specialty of law is I do civil rights cases, constitutional law issues, and employment law cases.
Great. So if you are in the Orlando, Florida area, we want you to make sure that you look up Attorney Frank Allen, get in contact with him. He's a great attorney, and he can provide you with some valuable information and representation. Thank you again, Attorney Allen, for being on the show today. You've given our audience some great information, and we want you to continue to live chat with us, continue to interact with us, and we are so excited about this information that we're giving out to you today.
Thank you.
Thank you for being here.
Now we're going to turn to the state of New York and the hot topic of healthcare workers and mandates for vaccines. We're going to discuss the governor of New York's new mandate regarding healthcare workers and the requirements for vaccines.
Hospital workers across the state have until midnight to get their first dose of the COVID-19 vaccine or risk losing their job. Northwell Health, the state's largest employer of healthcare workers, says today about 24 managers who are unvaccinated have been, quote, exited from their system and are now working to exit remaining staff who are unvaccinated. New York Governor Hochul signed executive orders today to address possible staffing shortages starting tomorrow. Political reporter Dave Evans is live in Hell's Kitchen with the very latest. Dave.
This is so unnecessary. And I just want to appeal to the individuals to know that, your coworkers want you to do this.
Attorney Rossi Williams, you are not only a licensed attorney, but you are also a registered nurse. From a healthcare worker perspective, how do you feel about this mandate?
I believe at this point that the mandate is necessary. And the only reason I agree with that at this point is because the vaccination has been approved by the FDA. When we were just talking about an emergency use authorization, there's no way in the world that I would have agreed that healthcare workers should have been required to be vaccinated. Of course, employers, private employers, they have that right. Just as when I worked in the hospital, we had to have hepatitis vaccination, you have to have different vaccinations. And so that was required as part of the terms of being employed at a hospital. And I understand that. At this point, I believe it's necessary. I believe it is allowable. And there's legal precedence for this already, because again, we're now talking about vaccinations which have been FDA approved. We're in a pandemic, a global pandemic. Yes, I do believe that the healthcare workers should be required to be vaccinated.
Do you believe that there should be any exemptions for any type of healthcare workers that have like a religious exemption, whether they don't, necessarily believe in the vaccine? Do you think it should be any type of exemptions given to healthcare workers regarding the mandatory vaccine?
Yes, religious exemptions are allowed because they're allowed by law, even in other instances where vaccinations are required. I do agree with those exemptions. For me, that would be a different exemption, though, from a person just saying, I don't believe in taking the vaccination. Because we do know that there are also political reasons that a lot of people don't believe in taking the vaccination. And the law does not usually carve out an exemption based on political affiliation. But if we're talking about a medical contraindication, if we're talking about a religious exemption, the law already gives space for that. And I agree that in this instance, the law should do the same as well. I do believe in New York that a judge has ruled that those who have a religious exemption can be exempted from this requirement to take the vaccination.
All right. And I'm not necessarily a healthcare worker, but I do agree with you when it comes to the mandatory vaccinations because we are in a global pandemic. I do believe that once you work in a hospital and you expose yourself to, working in that environment, that the vaccine is required and it should be upheld. We're going to look at some more footage about the healthcare workers protesting having to have the vaccine.
And it's not a rule I relish.
We will not comply.
At hospitals across the state, rallies with healthcare workers.
We had to be there. We had to be there. And now this is what they're going to do to us. Fire us?
I'm going to stand my ground. I'm still going to continue to go to work until they actually tell me you cannot be here anymore.
Do you feel that the healthcare workers will have a cause of action based on the protest of the vaccinations?
No, not one that would prevail. This type of case has already been tested in another state, and the judges there have ruled that the employer has the right to demand these type of vaccinations. Again, it is not foreign to nurses to be required to be vaccinated. Hepatitis, different things, they're required to be vaccinated when they work in healthcare settings. And this is an employer's right. Now, you know that I am not a fan of government overreach in any way. So I do I do agree and love the fact that the nurses are out there making their voices heard, and all other healthcare providers who are a part of that cohort who are saying we have issues with this. I love the fact that they can exercise their constitutional right to be able to get out there to protest, to assemble, and to speak about this. Yet, that doesn't override the employer's right to demand these types of vaccinations, especially now that they are approved. So we may see more lawsuits as different groups begin to say, let's test this in our state. Let's see what the end will be. But based on current prevailing law of the land, I don't believe that they would be able to be successful against their employers. What they're asserting is that this is an infringement upon their individual liberties. Again, I think that would be very hard to prove when those same nurses to work at that hospital or any other hospital they've already had to be vaccinated. They've already had to provide proof of certain types of vaccinations. So I think it will be hard to advance a compelling or persuasive argument based on good law that somehow this now approved vaccination is different.
What about the issue of all of the vaccines have not been approved from the standpoint of the booster, the new booster that has come out? If the hospitals require those, do you believe that a nurse would have a cause of action for not taking that booster shot?
Not at this point, because the boosters are not being recommended for everyone across the board. I believe we're talking about people who are very immunocompromised, who are high risk, and who are in certain age groups, which the CDC is recommending, or Dr. Fauci is recommending should now take the boosters. By the time we get to the point where everyone is being recommended to take the booster, I would hope that at least one of the brands or one of the manufacturers would be approved. Because to me, that is a persuasive argument. If you are trying to force me to take what has not been an approved medication, an approved vaccination, and you're trying to place me in an experimental cohort, then no, you don't have that right. And I'm going to fight that, because everyone has the right to refuse to be part of an experiment on a medication. But I don't think we're there yet. I think we're just dealing with the regular vaccinations and healthcare workers saying they're not going to take them. And I think it will be interesting to see how New York will be able to combat this. The governor is saying that via her new executive order, she will mobilize the National Guard. She will request retired healthcare workers to return. She will try to bring in workers from out of state. But there's another state, California, also looking at following suit. So if all of these states follow suit and in turn cause their own shortage of healthcare workers, where will the pool that they're trying to pull from to replace those shortages come from? I think that these governments need to take the time out to listen to the healthcare workers and try to see what it is that they're asserting. Does it have merit? Because sooner or later, it will be the patients who will pay for not having adequate staffing. That is who will suffer the most.
Do you think the concern for that is outweighed by the fact that we are in a pandemic and the number one issue is keeping everyone safe from COVID-19?
I think in the minds of non-healthcare professionals like these governors, that's what they're saying. However, you really can't have one without the other. There is no either or here. And I think that's the fact that they're missing. If you continue to try to force your healthcare workers to take this vaccination, and you have so many healthcare workers who are unvaccinated and who are stating that they refuse to be vaccinated, and you overlook them, you dismiss them, the patients that you're trying to keep safe will suffer from that overlooking or that dismissive attitude, because the end result is that you won't have enough nurses at the bedside. And when we're talking about patients being on vents and in ICU nurses, ER nurses, these are nurses who carry a specific competence.
And Attorney Williams and I are also licensed ministers, so we always like to end with prayer. We know a lot of people are hurting, and we know we are still in the midst of a global pandemic, so we want to bow our heads in prayer. God, we thank you for your goodness. We thank you for your mercy. We thank you for your love and kindness, God. We ask that you be with us, be with these healthcare workers, God, that are making these tough decisions, that are on the front lines. God, we ask that you order their steps, God, that you anoint them to do what you've called them to do, God. We know a lot of people are hurting or in the hospital, are bereaved. We ask that you provide strength, comfort, and your anointing and your power, God, that breaks every yoke in our lives. And God, we give you glory today. We give you honor. We ask that you continue to anoint us for your service, continue to bless this show, bless all that shall view the show. In Jesus' name we pray. Amen. Amen. Thank you again for tuning in with us. We want to encourage you to still live chat with us. Make sure you follow us on the Attorneys TV show on YouTube and on Facebook.
Yes, you just watched another exciting broadcast of the Attorneys TV show, breaking down current events, no holds barred, with guests from across the nation. Streaming every Thursday at 7:30 p.m. Eastern Standard Time on YouTube and Facebook. Follow the Attorneys TV show channel now so you won't miss one show. And sign up to get a text reminder when the show goes live by texting the word The Attorneys TV Show to phone number 33222. With your host from the West Coast, attorney and minister Vicky C. Jackson, from the law office of Vicky C. Jackson in Tacoma, Washington. With your host from the Central Region, attorney and minister Urena Ricks Johnson from Ricks & Associates in West Bloomfield, Michigan. And with your host from the East Coast, attorney, minister, and registered nurse Rossi Williams from Rossi Williams Law Group in Miami, Florida. So save the date, watch, and don't miss the Attorneys TV show, streaming every Thursday at 7:30 p.m. Eastern Standard Time on the Attorneys TV show channel on YouTube and Facebook. And sign up to get a text reminder when the show goes live by texting the word The Attorneys TV Show to phone number 33222. See you next Thursday.